Intentionally provocative nature of the headline notwithstanding, there's an element of truth to the idea that with this week's ruling that the Aereo television antenna being declared illegal by this U.S. Supreme Court, pretty much every media and content sharing and manipulation device you own is in trouble. And we haven't even gotten to the point where naming a team Redskins will bring about gun control. I've written quite a few times from my not-a-lawyer perspective about patents, trademarks, and copyrights, and while if you approach it from a practical, pragmatic perspective, intellectual property's always been a fairly easy thing to deal with, the death of Aereo throws pretty much everything into disarray, and this is very, very bad. The U.S. Supreme Court made two very smart rulings this week, which renders the Aereo case all the more baffling. First, the court ruled that your cell phone can't be searched without a warrant. Earlier in the week, SCOTUS had held that software patents can't cover abstract ideas, and you can see a story we wrote about Facebook's newsfeed patent or this other one on an even worse software patent by clicking through. Each of these rulings suggested that the highest court in the land was starting to understand the business changes that a world so steeped in technology was creating. Combine that with earlier rulings specifically allowing recording and storage technologies, such as a VCR ruling several decades ago, as the most prominent, and it certainly seems as though Aereo's technology for providing remote antennas, which were, by the way, specifically configured by Aereo in such a way as to make them, by definition, nothing more than that, should have been upheld as legal, and yet, no. Well, during the hearing on Aereo, Supreme Court Justice Roberts asked a question that could have been interpreted either as, hey, you're clever, you've built a whole business on a legal loophole, or as, you mean Aereo's entire business is built on a legal loophole? How dare you? Well, clearly the court's decision, basically shutting Aereo down, didn't hinge on that line of questioning at all, since, even if the justices took the less flattering view, it isn't the Supreme Court's job to have an opinion on a business model based on finding a legitimate, emphasis on legitimate, legal loophole. It appears then that the Supreme Court's Aereo decision is based on the idea that a remote antenna is somehow different from an antenna you plug into a TV directly, or that by including DVR functionality, Aereo rendered itself a retransmission service, a la cable and satellite TV companies. Well, we'd all best hope it was the latter, and Aereo, if they wish to stay in business, can do so by assuming that was what happened, dropping the DVR part of things and continuing to operate until a slightly different version of this case wends its way through the legal system. If, on the other hand, what the Supreme Court meant in the Aereo decision was that the only way you can watch TV programming is by sitting in front of a device with a pre-specified and approved type of reception hooked up, then every internet-based form of TV retransmission just started down a road toward illegal. Do you like streaming TV programming to your tablet or your laptop? What about Chromecasting? All things considered, there's a certain irony in how broken the U.S. Supreme Court's own website is. Don't you think? I'm the Answer Guy, and I'll be back.